The LCIA, or London Court of International Arbitration, is a leading international arbitration institution. Its scope encompasses a wide range of disputes and areas of law. Let's explore the key aspects of its scope. Types of disputes. LCIA arbitration is widely used for resolving commercial disputes, including those related to contracts, joint ventures, mergers and acquisitions, and trade. It also handles investment disputes, construction and engineering issues, intellectual property rights, energy and natural resources, and financial services. Parties involved: businesses, individuals, states, state-owned enterprises, and multinational corporations frequently use LCIA arbitration. Geographical scope. The LCIA is designed to handle disputes involving parties from different countries, making it suitable for international arbitration. Applicable laws and rules. Parties can agree on the substantive law applicable to their dispute, and the LCIA rules govern the procedural aspects of the arbitration process. Types of relief. Arbitrators can award monetary and non-monetary relief, such as damages, interest, injunctions, and specific performance. Arbitration clauses. The LCIA handles disputes based on arbitration agreements included in contracts between parties, complex and multi-party disputes. The LCIA rules allow for the consolidation of related arbitrations and the joinder of additional parties. The LCIA's scope is broad and versatile, catering to a wide range of disputes across various sectors and involving parties from different jurisdictions. Its comprehensive framework, global reach and flexibility make it a preferred choice for international arbitration in diverse and complex scenarios. So how does arbitration even begin? Well, one party decides they want to use this method. They send a request for arbitration to the other side. This is like a formal letter saying, "Hey, we have a problem, let's settle this with an arbitrator." This request goes to the LCIA too. It's important that everything is in writing. This helps avoid confusion later on. The request will explain what the fight is about and what the solution should be. Think of it like this. You wouldn't start a board game without telling everyone the rules first. The request for arbitration is like that. It sets the stage for what's to come. Now, we need someone to make the decisions, right? These are the arbitrators. They act like judges in a regular court case. Usually there's one arbitrator, but sometimes there are three. Both sides need to agree on who the arbitrator will be. This is important. You want someone fair and impartial. If they can't agree, the LCIA will help choose. These arbitrators aren't just random people. They are experts in their fields like law, business, or engineering. This helps them understand the issues in the dispute and make a fair decision. Section 4. Rules of the game, how arbitration works. Arbitration isn't as formal as a courtroom, but there are still rules. The LCIA rules lay out how everything works, like a roadmap for the process. This ensures fairness for everyone involved. Both sides get to tell their side of the story. They can present evidence, call witnesses, and explain their arguments. It's like presenting your case in court, but usually less formal. The arbitrators listen to all the evidence and arguments carefully. They consider everything presented before making their decision. The whole point is to find a solution that's fair and just based on the facts. Section 5. Keeping it secret. Confidentiality in arbitration. One of the big advantages of arbitration is confidentiality. What happens in arbitration stays in arbitration. This is different from public court cases where anyone can see the details. This privacy is important for businesses, especially when sensitive information is involved. They don't want their trade secrets or financial details becoming public knowledge. Confidentiality helps everyone feel more comfortable sharing information openly. It allows for more honest and productive discussions during the arbitration process. Section 6. The final word, awards and enforcement. Once the arbitrators make a decision, it's called an award. This is like the final judgment in a court case. It's legally binding, meaning both sides have to follow it. Enforcement is how we make sure everyone follows the award. This usually involves going to court and asking a judge to enforce the decision. The LCIA's reputation helps ensure awards are taken seriously. The LCIA rules have evolved over time to become more efficient and user-friendly. They're constantly being updated to reflect the changing needs of international business. That's why they're so widely respected and used today.